International law is a body of rules and principles that determine the rights and the duties of states. It includes the dealings with the other states and also the dealings with the citizens of the other states, and also it determines what is a state. However, we need to take note that the principles, the materials, and the techniques applied in international law are actually much more wider. The sources of international law, according to Article 38, Clause 1 of the Statute of the International Court of Justice, the relevant sources are the international conventions recognized by contesting states, which are known as treaties, and also the international customs, which are the general practice accepted by law. So it can be distributed into three sources, which are formal sources, material sources, and evidentiary sources, and the treaties and customs falls within the formal sources. So in this video, I will be explaining how a treaty functions as a formal source of international law and how it can be used to regulate international matters. In addition, we will be comparing it with customary international law in terms of their effectiveness and the way they are formulated. According to Article 2, Clause 1, Paragraph A of Vienna Convention on the Law of Treaties, a treaty means that international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Treaties can be categorized into lawmaking treaties and treaty contracts, the former having a universal effect in its application, and the latter only applies to fewer states. Moving on to features, the parties involved have to be states as mentioned in Article 2 and Article 6. In order to be recognized as a state, the main elements according to Article 1 of Montevideo Convention on Rights and Duties of State, there must be a permanent population, where the group of individuals living together on a permanent basis. It does not mean that no immigration is allowed and there must be a fixed number of inhabitants. Besides, there must be a defined territory, and a government which they can exercise independent and effective authority over the population within the defined territory. This element is important as we can see after the November Revolution of 1917, where Finland was declared independence. The Commission of Juries still held that the legal status of Finland was unclear until the new government was able to effectively exert its authority over the territory. However, this does not mean that a state without effective government will automatically lose its statehood. Next, capacity to enter into relations with other states are also important. Moving on to feature number 2, there must be with intention and consent. According to Article 34, treaty does not create obligation or rights for third states without its consent. And also in Article 11, there must be means of expressing consent to be bound by a treaty. These two articles shows that without consent, no state will be bound by a treaty. Feature number 3, it will be presumed that there is no disagreement as provided by Article 36. In order to form a treaty, there are 6 ways. So 1 is formality, consent, signature, ratification, accession, entry into force, and registration and publication. So for signature does normally establish the state's willingness to be bound unless it is mentioned that it is subjected to ratification, acceptance, or approval. In any case, a signature means that the state will refrain from acts that can be considered as a frustration of the purpose of the treaty. Whereas for ratification, it is a 2-step express agreement to be bound by the treaty. It requires internal approval within the state. Thereafter, they will demonstrate their willingness to be bound through depositing instruments, normally to Secretary General of the United Nations, as seen in Article 82 of the Vienna Convention. A state can enter into a treaty through ratification under 4 different circumstances as seen in the slides. Accession is similar to ratification, but the difference here is it is usually used by third parties who wish to join the treaty after it has been signed by the other states. An example of accession is seen in Article 83 of the Vienna Convention. For entry into force, a treaty will be effective at the date specified by its provision, otherwise it will be effective once all the parties have established their consent to be bound by it. For a third party who wishes to join the treaty after it is already in force, then the treaty will start to apply on the third party once it establishes its consent to be bound, unless otherwise provided by the treaty itself. To registration and publication, Article 80 of the Vienna Convention also states that all treaties must be registered within the Secretariat of the United Nations. This is in line with the Article 102, Clause 1 of the Charter of the United Nations. However, failing to do so does not invalidate the treaty, but parties to it cannot invoke any organs of the United Nations to enforce the treaty as shown in Article 102, Clause 2 of the Charter of the United Nations. Whereas in order to form a customary international law, according to Continental Shelf case, the International Court held that the substance of customary law must be looked for primarily in the actual state practice and the opinio juris of states. So under actual state practice, generality, duration, and consistency are the element. According to Anglo-Norwegian fisheries case, a general practice as a universal norm must have sufficient widespread practice. According to North Sea Continental Shelf case, the degree of generality will differ based on the subject matter, as special weight may be given to the practice to those states whose interests are specifically affected by the subject matter of rule. This shows that not all states need to participate before the general practice can become law. Whereas for duration, there is no rigid time element for the acceptance of a practice as a customary law. According to North Sea Continental Shelf case, the length of time needed will be vary from subject to subject. And according to Malcolm, it depends upon the circumstances of the case and the nature of the usage in question. In certain fields such as air and space law, the rules have developed quickly, whereas in the others the process will be much slower. For consistency, the state must be reasonably consistent in practicing the custom. So the words constant and uniform have been mentioned in the Lotus case. This shows that the practice must be consistently practiced in order to form an international customary law, and it cannot be uncertain and contradictory. Whereas for opinio juris, it is the belief that what they are practicing is law. So, the customary international law must be opinio juris so that the states will establish a standard to follow the practice. However, this is very difficult to establish because what can amount to opinio juris is vague, as demonstrated by Germany and Italy and the contrasting North Sea Continental Shelf case. In the former case, the court held that a long-held practice by a state can amount to opinio juris, but in the latter case, the court held the opposite. This shows that the problem of vagueness was not resolved even after the courts have attempted it. Therefore, treaty provides more certainty as to how states are expected to behave. All provisions have been clearly written and have binding effects on the agreeing parties to the treaty. There are no arguments as to what is the law and what is not because states voluntarily agreed to be bound. Whereas for customary international law, it is developed by activities of international institutions as supported by James Anaya in the journal article. For example, the declaration of the Universal Declaration of Human Rights, which led to countries convening to set standards in relation to human rights. These are instances which are uncontrollable by the state, but they are nevertheless bound to comply. Thus, treaties serve to regulate international law better with more clarity and certainty. Reservation is a statement made by a state when entering into a treaty for the purpose of excluding themselves from the application of specific provisions. It modifies a treaty's legal effect specifically for that state which has made the reservation. However, if the treaty prohibits or allows only for specific reservations, then the parties to it must comply. Plus, it must not run counter to the purpose of the treaty. When a state claims that they are making reservations, it can be easily confused with declarations. In the Anglo-French Continental Shelf case, the International Court of Justice held that the statement made by UK is in fact a reservation, although the exclusive word used is declaration. This confusion may result in dissatisfaction of states since they might be forcefully bound by laws. Note that this disadvantage is not mutually exclusive for treaties. Although customary international law allows for persistent objector, which is an objection to prevent a state from being bound by customary rule, it is very hard for new formed states to apply. Besides, the guidelines in GPRT are also help with determining if a statement is reservation or declaration. In short, treaties provide more room for contracting states to negotiate and agree to disagree. To compensate for states which object against the reservation, Article 21, Clause 3 of the Vienna Convention provides that the reservation does not apply between them and the reserving states. Besides, Article 21, Clause 1 also provides that the reservation will be applicable to non-objecting states when enforcing the treaty in relation to the reserving state and vice versa. Thus, this established fairness in treaties is more effective in creating harmony among states. The effect of treaties are all listed in the Vienna Convention from Article 26 to 30. These provisions are strong proof that the Vienna Convention has provided for the majority of scenarios that are bound to be happen when parties are entering into treaties. This will ensure the predictability of the actions of contracting states. In contrast, under customary international law, states might have very different reactions in their degree of compliance. For example, in America, customary international laws are codified in restatement of the Foreign Relations Law of the United States. But in other states, they are not. This suggests that America is ready to apply such law more strictly than the other states. Even so, modernists and revolutionists had argued if customary law should be given the status of federal law. This is supported by Gary Bond in his journal article. Therefore, the heightened unpredictability of states' action might threaten the effectiveness of customary international law. Moving on to interpretation of treaties. According to Malcolm, true interpretation of international law will have to take into account three approaches: actual text and analysis of the words, intention of the party, and the object of the treaty. So according to Article 31 of Vienna Convention, it must be interpreted in good faith according to its ordinary meaning. Article 32 states that it can refer to the preparatory work if the interpretation according to Article 31 leads to absurd. In Article 33, the parties may refer to the authenticated language, which best reconciles the text in terms of purpose and objects of the treaties. Compared to treaties which are in written form, customary international laws are more vague, as the process of it being slowly considered as a norm that everyone should comply with it is not documented. It is developed organically. An example of organic development of customary laws is the role of NGO. Interestingly, when people want to commit to single purpose, NGO are formed with moral authority like the Red Cross movement. This natural process is entirely non-legal and undocumented, but through increased participation, they have been able to garner power to lobby for states to commit to the same purpose as they do, as explained by Steve Konovitz. Moving on to the next part, the ability to opt out of agreement is important. It gives contracting states more space to consider future possibilities and withdraw from outdated agreements as time progresses. The invalidation of treaties is provided by Article 46 to 52 of the Vienna Convention. Furthermore, Article 69 provides that an invalid treaty is void and any acts performed under this treaty before will not be unlawful. A treaty can also be suspended or terminated under the Vienna Convention. This further supports the argument that treaties are more flexible in its application and thus less punishing to contracting states when things change and they wish to retract from the treaty. The greatest flexibility is provided by Article 54, which allows the treaty to be terminated as long as all parties to it agree to do so. For customary law, this is impossible because there is no specific state to look to for obtaining consent in order to exclude the application of the customary law in your state. Article 60 to 62 provides for the termination or suspension of a treaty. Customary international laws do not have this strength of identifying when does a state have an obligation to comply and when does that obligation end. Indeed, as argued by Andrew T. Grossman, there is no consensus on how widespread a custom should be to require state compliance, so the duration of state practice is hard to identify. Therefore, treaties can regulate international law better with clearer rules for states to observe. In conclusion, from the analysis in terms of the characteristics, the ability for agreements to react to changing times, to effect interpretations, and the ability to facilitate harmonious negotiation of both treaties and customary international law, treaties are better to regulate international law. However, that is not to say that customary international law should be completely abolished. In fact, treaties give rise to customary international laws too. It is explained by Anthea Elizabeth Roberts in the journal article. Multilateral treaties can be used to deduce modern customs because if any treaties share the same principle, then that can crystallize into custom, thus generating new customary international laws. Therefore, as much as treaties are more effective, in reality, they complement each other in regulating international laws.